Hello everyone, this is lecture 7 on the Supreme Court Rules 2013. In this video we will discuss Order 6, which provides for constitution of division courts and powers of a single judge. Let's begin. Rule 1 of Order 6 provides that subject to the other provisions of these rules, means the Supreme Court rules, every cause, appeal or matter shall be heard by a bench consisting of not less than 2 judges who are nominated by the Chief Justice. So in short, all matters before the Supreme Court has to be heard by a division bench, by 2 judges bench. What is Rule 2? Rule 2 provides where in the course of the hearing of any cause, appeal or other proceeding, the bench, the division bench, considers that the matter should be dealt with by a larger bench. It shall refer the matter to the Chief Justice, who shall thereupon constitute such a bench for the hearing of it. So suppose me and you, we are in a division bench, we are hearing a matter in appeal. There is this question which we feel that no, it should be referred to the larger bench in interest of justice. So we will refer the matter to the Chief Justice and then Chief Justice will constitute such a bench for hearing of that matter. What is Rule 3? Every cause, appeal or other proceedings arising out of a case in which death sentence has been confirmed or awarded by the High Court shall be heard by a bench consisting of not less than 3 judges. This is a serious matter. Someone's life is on the rope. High Court has convicted and has awarded death sentence to me. Or the sessions judge had awarded and given me death sentence which was later confirmed by the High Court. Now these 2 matters have come in appeal before the Supreme Court. Will it be heard by 2 judges bench? No. Mandatorily, this rule provides that any matter in which death sentence has been confirmed or awarded by the High Court, it shall be heard by a bench consisting of not less than 3 judges. What is Rule 4? If a bench of less than 3 judges hearing a cause, appeal or matter is of the opinion that the accused should be sentenced to death, it shall refer the matter to the Chief Justice, who shall thereupon constitute a bench of not less than 3 judges for hearing it. So this is a bit different from Rule 3. In Rule 3, accused was already confirmed or awarded death sentence by the High Court. But in Rule 4, he came here with any other punishment than death sentence, and the Supreme Court, while hearing the appeal or the matter, found it a suitable case to award this accused a death sentence, rather a convict a death sentence. Now what? So as soon as this death sentence comes into play, the matter will be referred to the Chief Justice, and the Chief Justice, after receiving this request, shall constitute a bench of not less than 3 judges for hearing it. So whenever death sentence comes into play, it has to be decided by 3 judges bench. Either it comes from the High Court or it comes from the division bench of the Supreme Court. In Rule 4, we have to remember this word, is of the opinion, is of the opinion. So these 2 judges, division bench, is of the opinion that accused has to be sentenced to death. He has committed a heinous crime, rarest of the rare cases. It will also be heard by a 3 judges bench. And what is Rule 5? Rule 5 provides the Chief Justice may from time to time appoint a judge to hear and dispose of all the applications which may be heard by a judge in chambers under these rules. In the last video, Order 5, we had discussed powers of judges in chambers, the applications which have to be moved before him. You remember Rule 2? It talks about this. The Chief Justice may from time to time appoint a judge to hear and dispose of all applications which may be heard by a judge in chambers under these rules. Now, what is Rule 6? During the vacation judge sitting singly may, in addition to exercising all the powers of judge in chambers under these rules, exercise the powers of the court in relation to the following matters. So, Rule 6 gives power to the vacation judge. This rule is very important with regard to our examination for advocate on record. Questions may be directly put to you that what are the powers of a vacation judge? So we have to discuss it properly and we have to remember it. So vacation judge has been given powers of a judge in chambers under Rule 2 of Order 5. In addition to those powers, he will also exercise powers of the court in relation to these following matters. What are these matters? First, application for a special leave to appeal in urgent cases. When vacation comes, urgent cases come. So, application for a special leave to appeal in urgent cases where interim relief is prayed for, subject to the condition that the vacation judge shall not decide such a petition if it raises substantial question of law as to the interpretation of the Constitution. So it is very important, there is a substantial question of law involved, and that substantial question of law is about the interpretation of the Constitution. So Mr. Vacation Judge, you cannot decide it, sorry. There are other urgent cases in which interim relief has to be granted. Alright, decide it. But not those applications in matters which involve substantial question of law as to interpretation of the Constitution. What is substantial question of law? Substantial question of law, we may say, is a species of question of law. Those question of law which are of general public importance, or those question of law which calls for two alternative views, those question of law which there is a difference of opinion between the high courts. And even after these difference of opinion, I have searched and this particular question of law has not been settled by the Supreme Court. There may be some question of law which is decisive and its decision is based on its reply, pivotal question. So these are kind of substantial question of law. So if there is a substantial question of law as to interpretation of the Constitution, Mr. Vacation Judge, you cannot decide this interim application, you cannot grant interim relief. No. Now what is second? Application for a stay of execution of a decree or order or a stay of proceedings in civil matters. This he can decide. Application for transfer of cases under section 406 of the Code of Criminal Procedure. Application for a stay of proceedings in criminal matters. Application under Article 32 of the Constitution of an urgent nature, again see, which do not involve a substantial question of law as to interpretation of the Constitution. Sixth, issue of a rulemacy in urgent applications under Article 32 of the Constitution, which involve a substantial question of law as to interpretation of the Constitution. Then application of an urgent nature for transfer of cases under section 25 of the Code of Civil Procedure. Eighth, issue of notice in applications of an urgent nature under Article 139A, Clause 1 of the Constitution, and application of an urgent nature for transfer of cases under Article 139A(2). Now, what is Article 139A, Clause 1? Well, it is power of the Supreme Court to withdraw cases. And what is Article 139A(2)? It is power of the Supreme Court to transfer cases. So this is it. If you like the video, please share and subscribe.